So, I hope everyone can hear me at home too. What a pleasure, what an honor to open our session on dispute resolution and technology, online procedures. I'd say between online procedures and AI. I'm especially delighted to see, well, of course, everyone here, but also people joining us from afar, many friends, and I acknowledge my friends from NCTDR, Richard Sutka, Ian McDuff. I hope I'm not skipping anyone there. So it's wonderful to have you with us as well. So in this panel, which might have seemed like a unique panel within this conference, I actually, listening to the earlier panel and the introductory remarks, thought it was striking how well integrated it is, actually, certainly within this sort of broader, more expansive view of the mandate of the Cyber Center. And I note Amnon's comment on the social condition, and of course, what has to do more with social condition than disputes, dispute resolution, institutions of dispute resolution. And I note the issue of trust that kept coming up. Trust in how do we assess trust? And we know that processes are a central means for establishing trust. So how do we think of our processes in an era of online communication and the introduction of AI into the operation of these processes? So believe it or not, the field of online dispute resolution is almost 3 decades old. So when I started looking at this field, I was in Hebrew, we have a saying, I was a weird chicken. So it was kind of not many people understood what it was about.
A rare bird.
A rare bird. Okay, thank you. I needed.
Weird chicken sounds much more fun.
Oh, Organ thank you. That's when you try and and improvise. So this history of ODR, on the one hand, it's short, it's brief when you talk about history, right? But it's also super condensed. And ODR, which emerged in the mid 1990s in the e-commerce setting, actually emerged in an era in which it and the dispute resolution landscape more generally was defined by dichotomy. The dichotomy separating formal from informal dispute resolution, the dichotomy separating physical in-court or in-room proceedings from online ones, and the dichotomy separating what humans or human third parties can do and what automation or fourth party or however we want to call it, the machine can do in their place. And as we look at the principal milestones the field has undergone in these almost 3 decades, I think we can see this gradual blurring of the principal dichotomies, and of course, the most recent evolution or developments in AI and LLMs mark the blurring of the last dichotomy I mentioned of, sort of really the most basic assumptions and beliefs of what is inherently human and what the machine could do. And I think our panel today, I spoke to the panelists about this earlier, not only provides rich insights into these questions and, the sort of the connections among courts, ADR, and technology, but also touch on these issues of boundaries and blurring boundaries and appropriate roles. And last but not least, trust is going to be also an issue that will loom in the background. And I think what's exciting to see as we look into this field, that if 10 years ago we were struggling to find an example of these systems, we had a leading court, a couple ADR systems outside the e-commerce setting, then today, internationally, and even as we'll hear locally, we are already experiencing, I think, a booming of online proceedings and many questions about their appropriate role, appropriate design, and the connection between our technological choices and the values and goals we promote in our systems and processes. So I will introduce, I think, my panelists all together at the same time. So we don't have to do that later. Each of the panelists will have 15 minutes, so we can leave a little bit of time for Q&A. 3 of our presentations are in English. The last one is going to be in Hebrew, and we're going to provide some notes in the chat. And I think also just for those of us who are English speakers, I think you will be able through the PowerPoint presentation to also get the gist of it. And I will introduce the speakers by the order in which they will speak. So Dr. Hanan Mendel, who is also, everyone here is a dear friend and colleague, but Dr. Hanan Mendel will talk about judges and avatars. I think he's going to continue the thread of the blurring dichotomies, right, between decision support and decision making. He's a faculty member at the ANO Academic College in law and focuses on law and dispute resolution, engaged in courts, ADR, technology, and also a chief editor of the Democratic Culture Journal published by Bar-Ilan Faculty of Law and co-director of the Hebrew Research Network, HRN SSRN. We will then turn to Dr. Talia Schwartz, who is a postdoc at my own research lab, the DRA lab, and she will present her findings from a scoping review of the research she conducted. And the research, as she will tell us, focuses on perceptions of AI in dispute resolution and judicial settings, where the issue of trust is, of course, a major driving issue. Talia, as I said, is a postdoctoral researcher at the DRA lab, and her interests lie at the intersection of law, technology, and society. Among her works are the impact of gender, race, and timing on ChatGPT convictions predictions. Should look it up on SSRN, really interesting. And the use of social media by crime victims and bystanders as a self-help mechanism. And other studies as well. And Mr. Yigal Nierenberg, both of which are pursuing their doctorate under the supervision of Professor Miki Alberstein, and you have another, of course, supervisor. And they will discuss the role of AI in advancing the concept of the multi-door courthouse. So this is a technology group, but for those of us who follow alternative dispute resolution and the courts, this notion of the multi-door courthouse is sort of a central, what would we call it? Almost a skeleton of the field of dispute resolution, this idea that we need to create a match between the dispute and the process. And they will talk about how AI can help us in this endeavor. Yigal is a PhD student at the Department of Information Sciences. And as I said, his instructors, Michal Alberstein and Avshalom Elimelech, help him with his interest in learning how to harness novel technologies to address real world challenges. And I guess that's another dichotomy we're blurring here, the dichotomy between research and practice. As we said before, it's so important to connect the two, and that's something that in the field of dispute resolution we do all the time. So as we add technology, that's also another layer. Sari heads the Mediation and Conflict Resolution Clinic at the Faculty of Bar-Ilan. We're very proud to have clinics that address dispute resolution, and happy to share this trait with Bar-Ilan. And she's also the co-director of the labor law mediation project on campus. And finally, we will turn to Mr. Nir Gordon, who's the head of strategy at the Israeli Ministry of Justice. To those of you who have not heard Nir or haven't met Nir before, it's nothing you would expect from, well, nothing I expected from government, okay? So it's high tech meets responsible government meets creative sandboxes approach. Super impressive, and I've been in touch with Nir and his team for quite a while, and they've been doing simply striking work in advancing technology in our courts and tribunals. So he'll share with us some of his insights. He graduated from a bachelor's degree in law and business administration and started as a prosecutor in the state attorney's office. And then in the management unit of the prosecutor's office as a civil attorney, and for the past 3 years has served as head of strategy at MOJ. And he's responsible for the long-term plans of the office and has headed, he'll tell us about it, an amazing, super important project on enhancing access to justice, which has a very broad and expansive view, and of course, technology plays a major role. So I've talked too much. I'm going to be quiet, and we'll start in this order with Hanan. Please go ahead.
Thank you. Thank you very much. When I first drafted the paper and the presentation, it was like 2 months ago. I was wondering whether I had to change it if things will change in the technological sense. And it seems like I had to change it, and not by technological sense, but by legal change. We talked about singularity before, and the saying of Werner Vinge in the 80s, that there will be a point where there will not be difference between humans and AI. And we had a prediction of Ray Kurzweil about the singularity issue that predicted this will happen at 2045. It seems like it's happening today. 3 weeks ago, a case was decided in the federal 11th Circuit for Appeals at Kevin Newsom, the famous judge, Kevin Newsom. The case was an insurance claim called Snell versus insurance company, and it regarded the refusal of the company to cover the damages that were done by a gardener, Snell, which was doing landscaping, but he was asked to install a trampoline on the right yard. The insurance company told landscaping, which is covered in the insurance policy, is not installing a trampoline. And that was the main debate on the case. But then Kevin Newsom said on his verdict that he's going to say something which is unsayable. He said that the question whether landscaping includes trampoline or not should be decided by AI algorithms which can interpret language better. And he offered to try and see what ChatGPT is saying about the issue and what other AI models are saying about the same issue. He didn't do it. He only warned that it will be soon. So an American legal blogger, a known one, Adam Unikovsky, took the offer by Kevin challenge and find that ChatGPT doesn't think the trampoline is included in landscape. But when he did it, he decided to do another test. He took 10 cases that was decided by the Supreme Court lately, He published this only 2 weeks ago, week and a half. And
For this
tried to see what?
For this conference.
For this conference, yes. For this conference, he published that he used for this issue not ChatGPT, but Anthropy cloud model. He gave all the questions that raised before the court in those 10 cases and asked the ChatGPT, the model, the AI model, to write a decision. Out of 10 cases, in 9 cases, without knowing the decision by the court, he predicted what the court will decide and wrote what Adam Minkowski wrote was even better verdicts and more convincing than the one that were done by the Supreme Court eventually. We know now that AI can write decision and can make decision. And this is the first phenomena that we have to talk about. There are cautions. We saw that in several cases, the AI model used imaginative verdicts cases. He only fabricated the names, but usually without referring to the question of how to cite cases, it was going the same direction as the court. So this is the first phenomenon. We now know that AI can replace judges, and we can send all of them to pension, or maybe as Rothman and Levin want, to kill them all. But eventually, the phenomenon that AI
Just
will
replace them with-
replace judges.
Shakespeare.
Yeah, Shakespeare.
Don't confuse the Levin and Shakespeare.
That's the first phenomenon. The second phenomena regard using avatar. In several studies done in recent years, it was found that people tend to rely more on a human decision than on AI decision. In other studies, the question whether it was a human or an AI was disguised from the people that participate in the research. And all the findings show that people cannot predict or know whether there was a human decision or an AI decision before. And this phenomenon leads to the question, what will happen when we use avatars to disguise the decision? We can take Aaron Barak and we can deep fake him. And we can write an AI decision and publish it under Aaron Barak name, picture, and voice, if you want.
We have enough data.
We have enough data. We have enough data. Though about talking, I'm not sure, but about writing, of course. AI can use it to write like Aaron Barak. But the question is, what will happen if we do it in fact? It is not done by courts. Usually governments and democratic regimes tend to be very careful about using such, disguising technically. But it's already done in arbitration and in mediation. In some cases, even in Israel, people were using an avatar in order to give confidence for the parties. Think about whether the judge is religious or a Jew or an Arab. And if you want to disguise this identity, the arbitrator, of course. So in some cases, I'm not talking about the famous cat a film which shows
A lawyer.
Yeah.
lawyer that was talking to judge with the avatar by Zoom. It's very simple to do this. And the question, what will happen when it's moved from arbitration and mediation into the courts? And my main claim is that that could change the whole thing. The only reason that we today know how to distinguish between arbitrators, mediators, and AI systems is that they were given not with a human avatar, and that are written in a different language in some cases. Both of these things are going to change. And then we have to redo all the studies, whether people rely on AI more than a judge, and whether people can try to
Differentiate.
find which one is behind the decision. This goes to and that's the thing that I finish with. This goes to term in the development of technological use of not even AI, but digital tools in the courts between decision support systems and decision-making systems. It seems like this distinction going also not to be not relevant. Whether we use, for instance, a calculator to determine the it could be like a but it could be also about in criminal cases what is the number of years that you have to give according to the rules that we have in this case. If you use a system that was already done and invented, and whether the court will sign and say, this is my decision. I use the system to calculate the years. It's become much not relevant. And that's why I think that we'll have to re-examine what people think about AI decisions. I thought it would be in 2044. It could be on 2020, 25.
Hanan, thank you. That I'll just say this because I'm having difficulty remaining quiet, but I'll just say, A, it was fascinating. B, I commend you on the time, and C, that's a perfect segue to Talia's talk about perception of AI. But I'll just say this. I think really, continuing from Richard's writing on is court a place or a service, and his more recent writing on AI, the questions that arise are some of the most basic questions about what makes each of these processes a distinctive process. What are they all about? And what is the role that the particular human third party plays there? How is that still relevant in making that the process it is and in generating trust in such process?
That's singularity, by the way. That's the term.
Will we have a,
Yeah, we'll do a round. Do you want questions now or should we?
I mean,
You're the moderator, you
Yeah.
decide.
At the end, and then we'll also have the interactions
so
between
you write
everything.
down.
I just feel there's write down your questions and then we'll open up.
Send them by
we'll
the
get
chat
your,
Zoom.
AI will
I
answer,
have an AI
answer that.
Just
Yeah, I will
to,
answer.
share.
So maybe as Orla finds the presentation, I'll start off by saying,
You're right.
And then. No, don't have so.
so I'll start off by saying, hi, everyone, pleasure to be here. Thank you so much for having me. So Orna presented me very well. I'll add a few interesting stories. So I'm Talia. I'm a postdoc working at Orna's lab. and I'm also a fellow at the CCLB this year. You know, 10 years ago or so, when I graduated from the Hebrew U, I interned for the state attorney's office. That's where I met Nir. And I was very privileged to be exposed to high profile, very kind of political cases. And I think that's where the initial thought of a data-driven legal system and channeling discretion came to my mind. And with that, I flew to Berkeley. I've been living there with my family for the past 10 years. And I also have some experience coming from practice. So I like to refer to me as myself also as a kind of rare bird, having affinity for applied research, working for Google and Logix, a legal tech automation company. Okay. Yeah. So as Lorna said, the kind of overall focus of the lab is looking at the vanishing trial and the centrality of the third party and how this kind of trend is being in a way disrupted by automation. And I think in our attempt to understand this disruption, see? Sure.
Yeah.
One of the things that we kind of tried to do initially is try to map literature of where we stand. And what we realized overall, we found this growing body of literature where on the one hand or one pillar, we see what we can refer to as broadly as social science, having literature that deploys both empirical and theoretical studies on the impact of AI on substantive and procedural justice. And then we have HCI, human-computer interaction, where we have these studies from different fields looking at model attributes and specific system characteristics and how these impact users or users' experience or overall trust. I think that's where we kind of place dispute resolution automation, DRA, the lab, somewhere in between, with kind of having legs in both major fields of this really interdisciplinary research. And very interestingly, I think that one of the major things we identified early on, and that's one of the major gaps that I will talk about later, is the fact that a lot of the studies in this field are done outside of the judicial or dispute resolution context. So we found a lot of them to deal with HR, organizational context, things that are, of course, with healthcare, where we see more and more automation and AI involved. So that's one of the gaps that I want to. Yeah.
Policing.
Policing, which we, I mean, able to identify also in judicial in a sense, but correct. So this kind of work on literature review ended up being one of my largest projects this year. So what we did, we decided to focus on perception towards automation in the judicial context within those kind of studies that we overlooked. The underlying assumption when deciding to look at perceptions and trust, as a lot of you here coming from the legal sphere know, is the fact that over the years, we know that trust and legitimacy in a decision-making authority leads to overall perceived fairness, legitimacy, reliance, obedience, social order. So that's our initial focus. So what we did is this systematic review, also called scoping review, where we have a predefined criteria to kind of map around our literature, where we excluded out things that are outside of our scope, whether it's non-AI, meaning traditional kind of procedural justice studies, things that are outside of scope, as I said, healthcare organization, even within predictive or not predictive policing, or things that are semi-judicial but doesn't deal directly with decision-making or disputes, we kind of left them out. And we use the traditional systematic review methodologies of both database searches as well as snowball and citation tracking. We ended up with about 5,000 papers falling in our kind of broader net, but then narrowed down to 28 papers. I want to consider this a work in progress, so don't quote me yet. It hasn't been published yet. Where we see, again, you can see a little bit about the specifics of how we ended up with that. And now, if we try to make sense of all of it, maybe we can. That here. Here. So as for our findings, obviously, we don't have the time to go over all of them. We have some very interesting findings, starting from the types of participants, the sample size that vary greatly, the demographics, the various controls, all of which connected to how we can predict whether it's preferences or attitudes towards AI. And again, I won't go into that in detail. One very interesting thing that came up is how experience with a prior experience, knowledge, to an extent, gender as well, is able to predict appreciation versus aversion of AI. What I will share with you is some of the kind of broader or major findings. First and foremost, with regards to methodology. So the prevailing methodology in the 28 papers that came up is of survey vignette, meaning they're based on scenarios, kind of lab done methodology. We also see, as for preferences themselves, you'll not be shocked, and it was repeated throughout the day today. Overall, we see this aversion, meaning preference towards a human decision-making agent. But we do see some contradicting findings where we have this appreciation in more and more people. Some papers really kind of tilt the weight towards preferring an automated agent, which was surprising for us. I want to say that within those perception, it was interesting to see positive perceptions of a human agent, perceiving humans as more empathetic, allowing more voice and so on with regards to procedural justice angle. But it was very interesting to see that even in those studies that found a preference towards human, an AI agent is getting more and more positive attributes, such as being impartial, more accessible, cheaper, faster, and things that we didn't necessarily anticipated when seeing this overall trend. And this kind of led us to a finding that is also somewhat of a conclusion, maybe one of the major conclusions of this study, that at the end of the day, the preference or the perceptions of automation in judicial context is context dependent. And what we find is that case complexity, decision impact, task dependency, type of facilitation, and model attributes, things that have to do with the specific design of a specific system or algorithm, they all matter to the way that an individual evaluates and kind of makes their selection in between those agents, or the way that they describe the authority as being fair, useful, or not. Now I'll take you a little bit maybe away from this specific research into the lab more broadly. So as I said, when we started this literature review, the idea was to really map where things stand and to shape our research agenda. And we came up with this kind of three overarching overall gaps that we were able to identify. So as I said, methodologically, what we see is that the vast majority of these studies are not behavioral in nature. They don't rely on real systems. They're vignette based, and which obviously bring questions as to their applicability to real life disputants, having the emotions that are involved in having a real dispute in different contexts. The other one is that the most of these, but not all, are in the narrow criminal context, and judicial meaning formal processes, not involving type of procedures, which is of course very relevant to ADR, ODR. But one of the things that we kind of questioned ourselves is there any reason to assume that these findings translate across the board to different types of disputes, different roles that the third parties make, whether it's mediators, arbitrators, and judges? Are people viewing that the same? We can't really talk much about that because most of literature deals with the judicial and criminal context. And last but not least, the fact that the findings, even though we see this aversion, are contradicting to not limited extent. And in that way, we thought that maybe the approach should be contextual as we move forward. So as I said, these gaps kind of helped inspire our overall lab mission and agenda. And we came up with this few highlights or blocks that we would like to fulfill. So the first is really take out the studies and expand them, not just formal, go beyond criminal and traditional formal decision making, beyond judges, beyond just courts, and look at a variety of processes and dispute realms, bearing in mind, process pluralism and the vanishing trial overall. We also want to make sure that we address different types of AI modalities, which is something that we're already beginning to see working with different platforms. So, the different functions that the AI fulfills, the stages that it comes into use in a specific system, what are the capabilities, right? When we talk about technology that is, let's say, dumb or more flat in terms of uploading documents or allowing facilitation, video or audio versus incorporating AI, more advanced analysis. These are, or might be two, or a whole spectrum there of attributes. We're committed to looking at real cases. So as I said, this is one of the major findings. We're very lucky to be able to collaborate with a few platforms, Justice 42 in Netherlands. And I also should probably mention Joel and Alex working with us on Amica in Australia and CRT in Canada. Hopefully, the Ministry of Justice any day now, working whether on pilots or on existing systems, in really trying to understand all of this theoretical work and how it comes to play in practice. And last but not least, what we term as legitimacy by design, we try to connect theory and these thoughts about design choices and models, responsible AI into values that we all want to push forward, whether it's access, equality, and fairness. I'll conclude with just presenting briefly. So I presented to you the scoping review. We're also working on, as I said, GRA in action. So we have several projects going on looking at real systems. We currently are at this final stage of conducting or implementing our conjoint study where we look at attributes and preferences toward dispute resolution automation systems. I think that really builds up on what you said, Hanan, in terms of how the research shifts from asking people to give their preference as to a human agent versus AI, and leaving aside the human. In this conjoint experiment, we're looking at our two systems that are compared to one another. So assume there are not even a human coming into play, and just what are the different preferences within automated systems. And we also have this line of research looking at AI regulation, and hopefully to have a comparative angle looking at Europe and the US. Aside from that, for those of you that are interested, we can talk about it more afterwards. I'm also having my own kind of line of research that is more maybe avant-garde in a sense and not really academic, where I also, like Dal said before, I also like to play with ChatGPT. So these are just two of my current projects, looking at ChatGPT 3.4 and 3.5 and 4 and comparing conviction predictions. What we did, we took work with a Chinese colleague. We took a very well-known study by Roslinsky, one of the few to look at judges' convictions. So we took the scenario, we kind of stripped it down. Don't want to say anonymized because who knows what it means, but stripped it down of info and kind of manipulated race, gender, and also included priming in it to see how the convictions look. Very interesting. And this one is already published, though we are working on enlarging the sample. And another one looking at fairness and content moderation, where we look at the effect of annotators' characteristics in real data systems and how the data sets themselves are affecting hate speech classifications. So that's it, I think.
Thank you so much. I'll just say, you see how everything is connected and really, I think what you did in the scoping is show how the current research falls into the dichotomies that don't really reflect reality anymore. And don't cover the entire span of dispute resolution. So thank you so much, Talia. We'll let Sally and Igal present their research. And
Presentations.
yes.
It's a lot of
Yeah.
Yes. But it seems they already took one of the chairs. Okay, so I'd start with a story. A few days ago, a man came down to the clinic's floor as we are located in the basement, in the law school faculty. People don't usually wander by accident, and he didn't schedule any meetings. So I got out of the meeting with Igal actually. The bills or any documents explaining what they are planning to do with the money. So he's the man in the hallways with me, seeking for advice on what to do next. He is confused, struggling to understand how to proceed and handle his conflict. His first intuition was to take them to court, obviously, which is why he lost his way down to the clinics in the first place. So should I suggest him to go to mediation? After all, this is the clinical man. But would it be the right option for his needs? And more than that, what does he really knows about his options? From a conflict resolution perspective, we know that every person in every conflict have their needs, interests, and emotions that impact their priorities. But people are finding themselves, like my visitor in the legal clinic, drifting through an incoherent process and are bound to the legal framing of the dispute. Despite attempts, we heard about it earlier, despite attempts over the years to expand the use of alternative dispute resolution and findings indicating that most of the legal cases, we got tired to say, but most of the legal cases in court ending without a legal decision, but in various forms of settlement, ADR procedures remain as the alternative, and still the court is the main door, the starting point for most of the disputes. Frank Sander, we promised that we are going to talk about him today. Frank Sander suggested that we learn about the parties' interests, needs, and other goals, and then fit the right form to a specific phase. But in the end, his recommendation is to assume mediation as the default choice for every conflict. And if there is a downside for it in concrete dispute, just then suggest an alternative form. Our vision was to transition from the default process, from the default paradigm to a customized mechanism. We decided to develop an informed recommendation system based on machine learning. And that's why we're invited today. Our goal was to design a triage platform that integrates need, interests, emotions, and other features of the user and the conflicts. And we aim to broaden users' perspective about their options and provide them with coaching in conflict resolution skills and mindset, aiming to create an empowering and informed and by choice decision-making process. We were hoping to design, and this is still our hope, a system that can later be integrated into other ODR platform and combined with other self-help tools, such as apps that can predict legal outcomes. In order to develop our system, we needed a high quality of data, and as Talia suggested, we had to use data that does not yet exist. So for this purpose, we created an experiment system. We wanted to encourage the active participation in the experiment, as well as produce a tool that is already a self-help and training. So we developed a user-friendly experience app. We had the UX and UI expert for it. The experiment involved multi-type steps that the participant had to complete. The first phase, you can see it's the ML training workflow for every ML project, but also for us. In the first phase of the experiment, the participants were asked to answer a comprehensive personality questionnaire and a negotiation style assessment questionnaire. In the second phase, they watched short informative animation clips describing them the different options, doors, mediation, education, etc., to resolve conflicts. Then the participants were presented with a detailed story about the conflict. We collected very hardly real-life conflicts and from various fields: consumer, finance and debts, neighbors, disputes, contracts, and commercial conflicts. The stories were presented from the eyes of the private human party that is facing the dispute and consider further action. Okay. For each story, participants were asked to rate the importance of their needs, interests, feelings, the other party's strengths in the conflicts, and to assess the intents of the conflict they are reading about. And in that phase, based on the knowledge they earned and their better understanding of the conflict and their goals, the participants chose their preferred door for handling this the conflict they read about. In order to gather quality data, in order to gather the data, we were looking for a crowdsourced platform. And we chose to work with Prolific due to its commitment to quality and diverse participants. Something we can share that almost all of our participants chose to respond to optional open text questions, which was an evidence for us for their commitment. Another advantage for using the Prolific platform was the ability to automatically collect user demographic details. And as I mentioned, the ability to get diverse participants in the demographic aspect, gender, age, you can see it, country, etc. It is more worth mentioning that most of our participants are educated, bachelor's degree and higher. Above those details, we were interested in learning about the participants' experience in legal dispute and resolution and conflict resolution in general. According to participants' self-report, 86% of them were not involved in a legal dispute and had no experience with court or ADR. Today, we are planning to spotlight our insight connected to the list of goals that Sander and his colleagues suggested to make into consideration when sorting conflicts. As we mentioned before, we had asked the participant to read a conflict story and grade their goals and interests as if they were involved in this same conflict. Because we also we have this is the real experiment system. This is our picture from there. As you can see, they had to rank the importance of every interest, privacy, right to mix and the compensation, every interest from in a scale of from 1 to 5, presented as the emoji and the color. And now let's dive into our results and insights.
Okay, thank you, Sari. So, okay, so I'll try presenting the results here. So our initial step was to try to find any significant pairwise differences between each of the goals. For that purpose, we used the Mann-Whitney U test followed by Eclipse Delta. And here we can have two examples of those results for importance of creative solutions and public communication. We can see that, for example, public communication, we can see that participants that chose adjudication for public communication tend to rate higher on that scale, and we found this difference to be significant but small. On the other hand, adjudication was rated lower compared to well, mediation was mediation was rated higher compared to the other two options for creative solution. Similarly, we found other significant differences for other goals, other suggested goals by Frank Sander, though they were small. The changes were small. Okay, so I know it's a bit hard to hear, but we presented our participant 30 different stories, and the reason we wanted to show this table here is the distribution of the selections based on stories. So you can see that even though our participants were presented with the exact same story, the choices they made varied significantly. So for us, it represents a subjective understanding, the previous experience, the goals, the driving goals that each of these participants had while reading this story, and therefore he basically made a calculation, and which pushed him to the selection that he finally made. For us, these preferences or weights for each of those goals are the basis for understanding what is the driving force for participants, or basically when they are thinking about how to handle their disputes. So here we're breaking down the dispute, these stories and selections based on the fields. So we can see here that, for example, banking and tort conflicts had tendency towards adjudication, and consumer contracts and neighbors had slightly higher, were leaning towards mediation. And we can well, we can see that we can understand it by several ways. So one can explain that there are still some sort of a fixation in specific fields towards that seeing that adjudication that is only suitable for certain types of dispute fields. Yes, and while that does not require any expert opinion or so. You can also see that people tend to be like maybe more open. If we're talking about consumer, for example, for consumer disputes, the possibility of proliferation of ODR system with e-commerce that open the public at large for basically that presented it with alternative means for dispute resolution that proven to be effective and efficient, and this also could probably help the public at large for educating them that the ADR also provide viable options. I'll try to move faster. So here we can see a confusion matrix for a model. Well, it's hard to see here. Yeah, no. No, I need that.
Might have been disabled.
Oh, loaded? Yeah, loaded. Yeah, okay, so here is, this is a confusion matrix that, showing the actual selection and the predicted selection based on the Sander and Rosier prediction model. And what is interesting here, well, first of all, it's we can clearly see the bias towards mediation as we would expect. But what we're seeing here mostly is that no participant passed the threshold for to be suggested the adjudication, even though 469 samples, this was the preferred choice. Yeah, so we're trying to move away from this adjudication by default, and we're trying to suggest other options. Well, we believe that placing external okay, so we believe that placing external weights in addition to internal weights for each of the procedure would make a model that's better suited for most cases. Fortunately, machine learning is designed specifically for that. So the model that the algorithm that we chose that showed the best results was is called XGBoost, or extreme gradient boosting. And what it also showed us, and it's interesting, that for example, our participants show that they placed much higher value for example, mean and max compensation when compared, for example, to maintaining privacy. So yeah, so the people are, even though they are ranking the same, but the value each the participants had for each of those goals is it varies. The XGBoost prediction model. Well, first of all, we've seen here that we try to predict, and it's not great, but still there is quite a good prediction for both adjudication and mediation, where the accuracy is set for 46%. Even when we are accounting for imbalanced sampling, which we had only for each of our selections, we believe that adding additional features for this model would greatly increase its accuracy.
46% and so there's just
Something that
yeah,
we-
50% is
Yeah.
random.
Well, no, it's not random because we have 3 options.
Right,
Yeah. So yeah,
but
but
slightly more than.
yeah. So it's not exactly, it's slightly higher than random.
Yeah.
But yes, again, but we only focused on the goals,
Right.
the features. Yeah. So we did not account here for any demographic information, any facilitating features or anything like that. Just to show that there is a value here, that just to show that there is a way to predict preference based on features of the case and the goals. So overarching objectives of this is obviously to increase the accuracy of our model, and eventually form it into a more of a persuasion-based recommender system. That we're seeing that even there's like a fine line between persuasion and recommendations. So we believe that placing an informed and well thought recommendation would be really beneficial for our users, and it would help in de-escalating and increasing overall satisfaction, and we believe that this would be a good way of going forward if we're planning to make ADR more acceptable by the public.
Wow, that was fascinating, and I think one of the things we see when we connect technology and dispute resolution is how they both take us to the place of focusing on user needs and desires. So technology, the methodology is really all about approaching the users and thinking of the interface, right? And we have that convenient infrastructure for collecting these views as well. And then in dispute resolution, we know, the sort of theory in dispute resolution for decades has been, let's see what the user's needs are and design the processes and approaches around them. That was super interesting. I just want to say, and I'm sure someone will ask this later, but what looms in the background in all of our discussions is sort of the relationship between subjective perceptions and objective measures, and we can talk about that some more later. So Mia, thanks so much.
So, excuse me, but I'll talk in Hebrew, so, yes. So I guess most of the people here speak Hebrew, and it will be easier for me. ואני רוצה לדבר קצת על, באמת אני אתחיל אחרת. שמענו פה הרבה מחשבה על איך AI יכול להחליף שופטים, והאם זה יתקבל ומה עושים, ואני רוצה להעלות פה שאלה, האם בכלל טרנספורמציה דיגיטלית מכריחה אותנו לחשוב בדיוק אותו דבר, מכריחה אותנו לעשות את אותן פעולות, והאם בכלל הצורך שלנו הוא לפגוש שופטים בקצה, והאם בכלל זה הכיוון הנכון ללכת אליו, ואני אנסה בהתחלה רגע לגעת בלשמה. למה בכלל אנחנו עושים את התהליך הזה? מה הבעיות בכלל שמטרידות את האנשים? ואני אנסה אולי להציע מחשבה שאולי יש דרכים אחרות לפתור את הסכסוכים, וההכנסה של AI דווקא למקומות השיפוטיים הוא אולי הכי קשה, הכי נתון במחלוקת, הכי הרבה בעיות אתיות יש לנו במקום הזה, ואולי בכלל את הבעיה של הצרכים המשפטיים אפשר לפתור באופן אחר לגמרי, וגם בסוף נגיע לשופטים שיחליפו אותם AI, אבל עוד חזון למועד זה לא כל כך פשוט, לא בטוח גם שכולנו, למרות שהם מתעסקים בתחום כל כך מהר, היינו רוצים שיחליפו אותנו שם במקום הזה. אז יש המונח, יש קליקר, נראה איך הוא עובד.
לעשות
בסדר, אז מונח access to justice או נגישות למשפט הוא יעד אסטרטגי מרכזי של משרד המשפטים כבר כמה שנים טובות, ולמעשה הוא יעד אסטרטגי של הרבה מאוד משרדי משפטים בעולם, וגם אחד מהקליצ'יס באום ובמקום כזה. ומה זה אומר למעשה נגישות למשפט או פער הנגישות למשפט? זה הפער בין הצורך המשפטי שיש לבן אדם לבין היכולת שלו לקבל פתרון באופן מהיר, הוגן וזול, והרבה פעמים, אני אתן דוגמה מאוד קלה, אמא שלי מתקשרת אליי, הסוחרים שלי לא העבירו לי צ'ק, חייבים לי 10,000 שקל, מה אני עושה? ואני אומר לה, וואלה, את לא עושה כלום. יעלה לך יותר כסף ללכת לבית משפט ולקבל את הכסף שלך בחזרה, ופעם באה תקחי ערבויות טובות יותר, וכל הדבר הזה יוצר איזה כדור שלג שפוגע בשוק ומעלה מחירים, ולמעשה יש מחקרים בעולם שמצליחים שפער הנגישות למשפט יש לו ממש השפעה על הכלכלה ועל ה-inclusive growth, על הצמיחה המכלילה במדינות, ויש ביניהם מאיתנו. אז הנושא הזה של פער הנגישות למשפט הוא למעשה הלשמה, את זה אנחנו רוצים לפתור, זו המטרה שלנו לפחות בהליך אזרחי, במשפט אזרחי, אנחנו רוצים לצמצם את פער הנגישות למשפט, ושלאנשים יש בעיות, יש מחלוקות בינם לבין אנשים אחרים, יהיה להם דרך לפתור אותה בדרך הקלה והנוחה ביותר. פער הנגישות למשפט בישראל הוא משמעותי מאוד, הוא יותר גדול מבעולם, עשינו מחקר מאוד מאוד גדול במתודולוגיה שמקובלת בעולם, ולמעשה 69% מהאנשים בישראל נתקלו בצורך משפטי בשנתיים האחרונות, שצורך משפטי זה יותר מבעיה משפטית, יש 80% נתקלו בבעיה משפטית, צורך משפטי זה בדרגת חומרה מסוימת, שהם גם לא יכולים לפתור אותה לבד, זאת אומרת שהם נזקקים לאנשים, ולמעשה אנשים חווים יותר מבעיה אחת, למעשה 3.5 בעיות בממוצע, אנשים חווים בממוצע בישראל, כך שמדובר בצורך משפטי.
איזה זמן? שנתיים?
לשנתיים, בטיים פריים של שנתיים. עכשיו, דיברנו על סובייקטיבי, אובייקטיבי, זה נעשה בסקר, סקרנו למעלה, זו המתודולוגיה מקובלת בעולם, סקרנו למעלה מ-2,000 אנשים, נתנו להם שאלון, ונכון, יש פה עניין סובייקטיבי, וכמובן שלא כל הבעיות האלה מגיעות לבית המשפט, אני אשלח אחר כך, פרסם גם את הדוח בימים הקרובים, שיהיה לנו אישור וחתימות, ופער הנגישות במשפט הוא...
יש פער נגישות בחתימות, זה גם...
ופער הנגישות במשפט למעשה הוא בהרבה מאוד תחומים, ודיברו פה קודם על התחומים, ואיפה בתחומי המשפט, אז הוא דומה, ההתפלגות דומה לעולם, כמעט בכל המקומות גבוהה מבעולם, לא נתתי קודגרף, אבל יש גם פער בין כמה בעיות יש ובין החומרה כאן. אז אנחנו רואים שנגיד בצרכנות יש הכי הרבה בעיות, אבל הן לא הבעיות החמורות, ולמעשה במשפחה יש פחות בעיות, אבל זה כדורי שלג שגורמים לנזקים הרבה יותר גדולים, ובסוף עשינו בדוח הזה, עשינו כבר איזה מחקר השוואה בין הכמות ובין הבעיות, זה למעשה מה שאנחנו רוצים להתעסק בו, ואני עוצר פה לדבר על זה, ואני רגע רוצה להגיד, שני דברים השתנו בעולם. פעם יכולנו לפתור, פעם היה מאוד קשה לפתור את פער הנגישות במשפט, ומה שהיינו עושים, והיינו אומרים, אני יכול להוסיף עוד שופטים, זה באופן ליניארי, ומאוד קשה לפתור את הבעיה הזאת, אני יכול להוסיף עוד סיוע משפטי, לתקנן עוד, זה עולה לנו המון כסף, המדינה מציעה 250 מיליון שקל בשנה על סיוע משפטי, לא ברור כמה אפקטיבי האירוע הזה, שני דברים קורים בעולם שמשנים את התפיסה. אחד, טכנולוגיה, תכף אני אדבר. הדבר השני, ופה אני קצת רוצה לגרות תיגר, הוא הבנה שליגל ג'רמי או מסע לפתרון בעיה משפטית לא חייב להיות בבית משפט, ופה אני רגע רוצה לדמות מעולם הבריאות דווקא, לקחת דוגמא, ולא כל אדם שכואב לו הראש צריך לקום ולהגיע לחדר ניתוח ולהגיד אני רוצה ניתוח מוח, בואו תנתחו אותי, הרי זה לא הגיוני הדבר הזה, אנחנו רוצים שיפתח אינטרנט ויקרא ויקח אדוויל, ואם לא עובר לו כאב ראש אחרי כמה דקות או אחרי כמה שעות, הוא ילך...
זה מה שאנחנו רוצים.
לא, מה אנחנו רוצים?
שיפתח אינטרנט וימצא לעצמו תרופה באינטרנט.
שיעבור, בסדר, אבל לא היינו רוצים שיגיע לחדר ניתוח, רוב הדברים היום מקבלים, וגם רוב קופות החולים היום מפתחות את המענים שאפשר מהבית
עם רופא.
לא בהכרח עם רופא, זאת אומרת יש להם ממש שאלון שבנה אותו רופא והוא מובנה, אבל את רוב הדברים אתה יכול למצוא לעצמך את הדבר הזה, ודומה לזה בעולם המשפטיות, לא כל בעיה צריכה להגיע לבית משפט, הוא יכול לקבל ולהיכנס ולחפש מה הפתרונות, ואנחנו צריכים לדאוג שיהיו לו את הפתרונות לגישים, יכול ללכת אחר כך לגישור, יכול ללכת, ומיעוט המקרים צריכים להגיע לבית משפט, ושינוי הגישה הזה הוא אחד השינויים המשמעותיים שיכולים לתת לנו למעשה לפתור באמת את פער הנגישות למשפט, וכלים טכנולוגיים יותר קל לנו במקום הזה. אנחנו מדברים עם משרד המשפטים על סוג של מצפן, שאומר שכמה שאנחנו יכולים לפתור בעיה בשלב מוקדם יותר של הבעיה, ובאופן יותר עצמאי סלף-סרוויסי, כך איתיו, זה כמו ששריפה אפשר לכבות בכוס מים, תפסנו אותה בזמן נכון, בעיות משפטיות נוטות לגדול, אם יש לנו סכסוך משפחה או גירושים שלא נפתר בהתחלה, הוא יוצר עוד ועוד ועוד בעיות, אותו דבר עם נזילות, אם הייתה נזילה מהבית מעליי והייתי פותר אותה בשעה, לא היו נגרמים נזקים, בדרך כלל תיקים מגיעים לבית משפט אחרי שכל הבית נהרס, ואיתו יש כבר תביעה ענקית וקשה מאוד להתמודד איתה, אז המצפן אומר בואו נפתור את הסכסוכים בשלב מוקדם יותר, ופה טכנולוגיה ממש יכולה לסייע לנו ולעזור בשלבים דומים, ולא נצטרך את השופט AI שיחליף אותו במקום הזה. בכל זאת אני רוצה קצת לדבר על טכנולוגיה, אני רוצה להגיד, אנחנו באופן כללי מחלקים את פער הנגישות למשפט לשלושה דברים מרכזיים, ובכל אחד מטכנולוגיה יכולה לעזור. הראשון, יש לנו המון בעיות משפטיות, בעיות משפטיות נובעות הרבה פחות משני דברים עיקריים, בדרך כלל חוץ מהתרבות הישראלית שאנשים מאוד אוהבים לריב, זה נובע מחוסר ודאות משפטית, שטכנולוגיה בטח יכולה לתרום לדבר הזה, והם הסדרים משפטיים לא טובים, לא הכי טובים בעולם, למעשה שיש לנו את ההסדר שאני יכול לקבל כסף חזרה אחרי 14 יום שקניתי מוצר, אין סכסוכים משפטיים כי ההסדר הוא נוח, אבל כשמתחיל עסקת מכר מרחוק בתנאים כאלה, אנשים לא מוצאים את הידיים והרגליים ומתחילים סכסוכים משפטיים. במקום הזה יש כמה פרויקטים שאנחנו עושים אותם, של הפחתת כמות הבעיות. אחד זה חקיקה דיגיטלית, אנחנו בפרויקט מאוד גדול שהופך את החקיקה לקוד, זה יאפשר לכל מיני גופים אחרים אחר כך לקחת את החוק, להבין אותו, לייצר עליו פלטפורמות, מה החוק אומר בדיוק, מה המצב המשפטי בכל מקום כזה, אנחנו מייצרים פה סוג של תשתית שתייצר את הדבר הזה, פרויקט כבר בשלבים מאוד מתקדמים, ויש פיתוחים של כלים דיגיטליים שמנגישים את החוק, ולצד זה דאטה שאנחנו עושים להבין איפה הסדרים, הם הסדרים לא מתהווים, זאת אומרת אם יש סוג מסוים של סכסוך שקורה הרבה, אולי החקיקה לא נכונה, אולי צריך לחזור לחקיקה, אולי צריך לייצר הסדר משפטי נוח יותר וטוב יותר במקום הזה. אני אתן דוגמה קטנה שעשינו עכשיו בזמן המלחמה, נושא הסכסוך של השכירויות היה נושא שעלה כל הזמן, בנושא יצרנו סוג של שאלון, שאומר, רגע, מה הבעיה? כל אחד יכול למלא, לענות את השאלה, אני מזכיר, אני פוניקי, אני מיישוב כזה, מיישוב כזה, ובסוף אנחנו אומרים לו, זה המצב המשפטי שנותן לך. עכשיו, במסגרת הבנייה של השאלון הזה, גילינו את הדבר המדהים ביותר, שאין מענה משפטי לסוגיה האמיתית. זאת אומרת, אזרח שהוא מפונה והוא קיבל מענק, האם הוא צריך להמשיך לשלם שכירות או לא, ופה יש לקונה, אז קודם כל, עשינו כלי דיגיטלי שמנגיש את המצב. 2, מצאנו את הלקונה, לא פתרנו אותה, אנחנו לא מצליחים לפתור הכל, אני מדבר בכנות,
אחרי שהם עברו את זה, הם הגיעו לקליניקה שנעזור.
אז אני מדבר בכנות, לא הכל פתרנו, הבנו את הבעיה, הבאנו אותה למקום של קבלת החלטות, לא בהכרח הצלחנו, לא תמיד אנחנו מצליחים לשכנע, בהרבה מקרים אחרים אנחנו צריכים לשכנע שזה המצב, אבל זו דוגמה לכלי דיגיטלי שגם מנגיש וגם מאתר את
כתבתי להם שאתם ממליצים,
כתבנו להם, יש תוצאות, ממש כתבנו להם שאנחנו ממליצים להם בגלל שיש לקונה משפטית, אנחנו ממליצים להם להגיע להסדר כזה או אחר ולהתחשב ושזו דרך המלך לפתור את הבעיה. יכול להיות שהיה נכון יותר לייצר ודאות משפטית, לא תמיד אנחנו מצליחים ולא תמיד תלוי בנו ובמקומות האלה. הדבר השני זה מתן כלים, סליחה? הנושא השני זה מתן כלים לפתרון בשלבים מוקדמים יחסית של המקום הזה, אז גם פה יש המון כלים שאפשר לפתח, אנחנו עובדים עליהם דיגיטלית, נגיד בתחום הצרכנות, שזה התחום הכי קל. יש את החוק שאנחנו עובדים עליו עכשיו של תעופה, של החזר כספי, אם מתבטל טיסה או משהו כזה, יש חוק שהוא כמעט מתמטי, זאת אומרת במקום הזה, ופשוט אנשים לא מכירים אותו ולא מבינים אותו, קל מאוד למדל אותו ולתת פתרון, ובסוף אתה נותן מכתב בסוף, יצא לך מכתב ממשרד המשפטים, זה מה שמגיע לך לקבל בהתאם לביטול טיסה, וזה אמור לפתור את הסכסוך בלי בית משפט, זה יוצר ממש ודאות במקום הזה, ויש הרבה דברים אחרים שאנחנו כן משתמשים בהם ב-AI דווקא, זה יותר קל לבטל רגולציה או להקל על רגולציה, למשל לנהל סיכונים ברגולציה, שזה אל מול המדינה, זה בסכסוכים אל מול המדינה, למשל בנושא העמותות, אישור ניהול תקין, אז עד היום לוקח הרבה חודשים לקבל אישור ניהול תקין, כי יש בדיקה ידנית, אנחנו עושים מסלול ירוק, שיש חברות שעומדות בכללים מסוימים, עשינו פה מערכת דנטרוקיות שלא נותנת, זה יכול לתת לך, כבר בקיץ זה יעלה להעביר לדעתי, שנותן לך תוך 60 שניות אישור של ניהול תקין לעמותות, וזה פשוט מקל עליך את הבעיות, את כל הסכסוכים בהמשך, ובעתיד אנחנו נשנה את הרגולציה בהתאם, שלא יצטרכו להגיש גם כל שנה, מישהו נכנס למסלול הירוק, צריך להגיש אישור ניהול תקין פעם ב3 שנים, 4 שנים, לא יודע, מה שהמחוקק בסוף יסכים ויותר לרגולציה. החלק האחרון, ופה אנחנו מדברים עליו יותר, ובכל זאת כן, אם יש לנו סכסוך ואנחנו רוצים לפתור, אז מה אנחנו עושים איתו ואיך אנחנו מייעלים את הסכסוכים, ובמקום הזה אנחנו מתנסים ב-ODR והרבה מהסכסוכים שאמרתי, אפילו היית שלחת בן שלך לקליניקה, אז בתים משותפים יש כבר מערכת ODR באוויר, היא מערכת שהיא בשלב הראשון. בשלב הראשון מה זה אומר? זה אומר שהיא, בעיקרון מערכות ODR בישראל, אני לא יודע כמה מכירים, אבל אצלנו, לפחות תפיסתנו, מערכת ODR, זה 3 חלקים מרכזיים. השלב הראשון הוא הנגשת המידע, יש ממש עצים שדרך אגב נבנו ידנית, זה עצים שעדיין לא יתמשו בזה, נבנו ידנית ברעיונות של עורכי דין ושופטים, אלה הזכויות שלך, מה הסכסוך שלך, והוא ממש מנגיש לך את המידע, זה המצב המשפטי שלך. אצלנו אנחנו רואים שברוב הכניסות שלנו, או שהמענה לא טוב ואנשים נוטשים אותו, אבל רוב האנשים מסיימים את שלב האקספלורציה ולא מגישים תביעה, כאילו מקבלים תשובה, מקבלים את התשובה שמספיקה להם את המידע הנכון, השאלה...
זה משהו בוא יותר...
אני לא יודע,
כן, זה נשמע מדהים.
במצב שאתה רוצה בכל זאת להמשיך להגיש תביעה, הוא מסייע לך להגיש את התביעה, הוא ממש כותב בשבילך את התביעה ומגיש אותה לצד השני, אנחנו בשלב פה נעצרנו במקום הזה, בדיני עבודה, שזה המערכת, לא יודע, אני לא אפילו, לדעתי, בדיני עבודה, זה ממש המערכת, מתוך המסכים בדיני עבודה, אנחנו עושים שם עבודה הרבה יותר מעמיקה. בדיני עבודה, רוב הסכסוכים הם סכסוכים שיש להם תשובה. זאת אומרת, אם בן אדם פוטר בתאריך ככה וככה ועשה ככה וככה, והרבה פעמים אנשים לא יודעים את התשובה. אז יש פה ממש 14 מחשבונים שבן אדם עובר ומזין את הפרטים, שם את התלוש משכורת, מקבל, מגיע לך XMF
Great.
let's return to English. And we have some questions in the room. I also want to see if anyone at home has questions. We've had some internet problems here, so we might have been cut off. I apologize to the people joining us from home.
You'll
so-
receive a recording.
They'll
Everyone will
receive a recording, okay.
from the
But
conference.
two questions I see here, I think Amnon and Yuval and Pasha. So let's go three here, let's gather them quickly. And I'll also see if we have a question from them.
Okay, so quick comments. So for Hanan, the questions you've raised raise another question, and that is, are courts unique? So you said, well, we can generate Aaron Barak's AI. And then the question becomes, will it have the same authority? I guess you were asking, as Aaron Barak, and why not? I mean, if we've done a good job technologically, then it's as close to Aaron Barak as we can get. And if we think Aaron Barak's jurisprudence is well calibrated, as I do, but that's beside the point, then why not? So how about a rabbi? So if we have enough of the writings of Rav Ovadia Yosef, why not train the AI to be Rav Ovadia Yosef? And does it matter that Rav Ovadia Yosef supervises from the other world and not this one? But as it happens, this is the representative of. Is there something unique about courts, philosophers, rabbis, other people of authority, whose authority is part of what makes their decision credible or legitimate or whatever you want to phrase? That's question number one. To Talia, that's an impressive work. Thank you for doing this for the sake of science. The question becomes a question of Shempol group. So the idea was to splice off going on, but that's a different type of research, and we can talk more about it. With respect to your idea of persuading / recommending, there's a question of endogenous and exogenous variables here, or, dependent and an extreme condition, and then see which decisions have to be taken whom, and then to find what we call friction. Optimal friction is bad. So the idea, I'm finishing. So the idea is the more you focus on prevention, because you start from once there is a dispute. We know that the more you focus on prevention, you say, the more efficient you are. So we can talk about this more.
I'll try to be a bit short. So I have only a question for Talia, but it might be relevant for others, but Talia, you have these factors that, these variables in one of your slides, context, complexity, etc. I didn't see the issue of preference. I mean, where do you factor in preferences with regard to engaging with technology? Is this something you are controlling for?
Yeah.
Yes.
Or so you're controlling this across the board. And second, do you we are focusing here on judicial decisions. There is, of course, a broader question about your work on this spectrum as having any spillover to other places on the spectrum.
Let's collect all the questions and then we'll let each of you decide what you're.
So I think my question is mainly for the first two speakers, Tal and Hanan. I think that, again, alternative dispute resolution and AI in the judicial process might be a very interesting idea, but I think it's on the ethical borderline of what is permitted and what could be done. Especially when you look at the jurisdiction that we see in Europe and also as in the Colorado AI Act and the emerging legislation in the States about automated decision making, about the impact on actual human rights and actual humans of these decisions. So I think that the perception is very important, but on the other hand, the validation mechanisms and the bias version mechanisms and the self-check mechanism has to be embedded in this AI, has led the EU legislature to say that a lot of this is prohibited, or a lot of this is borderline prohibited, and maybe as we see in the Shufa case that was in the
בית המשפט, מסדרי זיהוי. מסדרי זיהוי צריכים לחלוף מהעולם, הדבר הזה לא טוב, טכנולוגיה מחליפה אותו הרבה יותר טוב, זה שימוש מדויק, נכון, מתאים להיום בטכנולוגיה. לגבי אמירות או שיפוט או אהרון ברק או מישהו אחר, אני עוד לא שמה במקום הזה ולא בטוח כמה מהר נהיה פה, וצריך, זה לא אחד או אחד, צריך למצוא את המקומות שהם מתאימים ואפשר מחר בבוקר, ואת המקומות שנהיה אחרונים בתור, וזה גם יגיע לא כל כך רחוק.
legitimacy by design. טוב, אז בנימה זו, תודה רבה.
יהיה לנו לאנץ' באדיג'אבה.
האמת שהתמה של טיילורינג לעומת מודלינג הייתה גם היא מאוד חזרה, אז הלאנץ' טיילור זה